Hey, everybody. Welcome to the Hammer Museum's online Constitution Happy Hour. It's time to shake off the workday and settle down with a drink and a great book. Constitution Happy Hour is like a book club, and we all read the Constitution together. You might remember that in the real life version, we have a bar and snacks at the Hammer Museum, and everyone gets a free copy of the Constitution to take home. So for our virtual incarnation, I hope you've all mixed a cocktail of your choice, and we'll have the relevant text from the Constitution all ready for you in the slides and pasted into the chat. The way this works is we have a speaker who will talk about the relevant constitutional issues for about 20 minutes. And then we have a Q&A discussion for another 20, 25 minutes, or for however long it goes. When we get to the Q&A portion, if you have a question, please raise your hands either digitally with the blue button in Zoom, or you can type your questions into the chat box. And we'll also look for physically raised hands during the Q&A, and you can ask your question out loud. Constitution Happy Hour is a lot more interactive than the Hammer Forum, and I think it's a lot of fun. So we get to see everybody in the audience, and it's really wonderful to see all of you back together again. We're going to try to get to everyone's questions, but we apologize if we can't reach all of them. Now, I want to ask you all to switch to speaker view. That'll work a lot better for the first half of this program. To get to speaker view, in the top right corner of your Zoom screen, you have the choice between gallery view, speaker view. Speaker view is going to let you see the slides properly so you can read the relevant texts. Also, please note that this program is being recorded and it's going to be available later on the Hammer website. So if you choose to keep your video and audio on, you might be visible and recorded. And if you want to opt out of that, you can just shut off your camera. So the Hammer's Constitution Happy Hour is part of a larger project called My Daily Constitution, which was created by the Los Angeles-based artist Linda Pollock. The idea is to bring together people and engage in creative dialogues about democracy and society. Linda first began My Daily Constitution in 2002 in response to the Patriot Act. And since then, she's initiated Constitution cafes in bars, libraries, cafes, parks, restaurants, churches, and other places where people gather, like the Hammer Museum. To quote Linda, "Our Constitution, our democracy is about interpretation. And interpretation means a collective active dialogue, not just passive consumers and lawmaking producers. The US Constitution is a living document, part of our quotidian life, influencing us in both large and small ways daily." So part of the reason that we're doing Constitution Happy Hour at the Hammer Museum is so that we can all see how the Constitution affects our daily lives. And we want these programs to be relevant in real time to what's going on in our country. So today's talk is going to focus on a very recent case that went deep into a granular discussion about the Constitution. Specifically, just 5 days ago, it feels like 5 months ago, but it was really just Saturday, the United States Senate completed the second impeachment trial of President Donald Trump and voted to acquit him. Much of the argument for Trump's acquittal boiled down to an analysis of the Constitution, with claims that it was unconstitutional to try a president who's no longer in office. There was also a lot of argument about what constitutes insurrection, what kind of speech is covered under the First Amendment right to free speech, and what is considered incitement to violence. There was a very fiery speech after the vote to acquit by the Republican leader, Mitch MCConnell, in which he sort of said, yes, Trump was guilty of everything in the trial, but had to be acquitted because of a constitutional technicality. So the trial's over, but I think we all still have a lot of questions. And we're all really lucky to have a brilliant legal scholar here today to break it all down for us. So our speaker tonight is Loyola Law School professor Jessica Levinson. Levinson studies the law of the political process, including election law and governance issues. Her work focuses on ethics, political corruption, and voting rights. She regularly appears as a legal and political expert on television and in radio and in print. She's the host of the podcast Passing Judgment and has a weekly legal segment on NPR member station KCRW here in Los Angeles. She's also an op-ed contributor for NBC.com and legal contributor to CBS News. And she's the associate director of Loyola Law School's Journalist Law School and the founding director of Loyola Law School's Public Service Institute, which is dedicated to creating the next generation of leaders in government service. Professor Levinson served as the president of the Los Angeles Ethics Commission until 2018. So as you can see, she is well qualified to lead us in this discussion. So hello and welcome, Professor Levinson. Cheers to you.
Oh, you didn't Tell me about it. You can't see it. It's really not vodka. It's just water.
Sure. I believe you.
I see Paul has his blue mug. Paul, I think it's vodka, but okay. I'm so excited to do this, and I'm so excited to see so many of you. We've been doing a lot of great forums that I've been honored to participate in since the pandemic started, but I haven't been able to see a lot of you. And as Claudia says, I think this will be more informal, and hopefully the majority of it will be us talking together. So the first thing that I want to do is actually to launch some polls, because I want to get all of you thinking about what we're going to talk about, and I want to see kind of where you are on some of these issues. So with that, it's making the Hammer staff incredibly anxious, but I'm going to launch the polls on my own. And let's see. Can everybody see poll number 1? So I'm slightly worried because, okay, we've got 1 vote. I see this is a highly educated group. I'm going to give it a couple more seconds. All right, in 3, 2, 1, I'm going to end this poll and share the results. The winner is, so the question, now that the Senate has acquitted President Trump or voted not to convict, depending on how you want to say it, can he still be charged in a federal courtroom? And answer B, yes, he can, because one of the things I want to talk about is that an impeachment trial is not really a trial. It doesn't create criminal law punishment, and it doesn't prohibit criminal law punishment. So we will, as I say to my class, we will unpack that in excruciating detail. And now I'm going to see if we can. Oh, can I read? Yes, I can. I'm going to see if I can launch the next poll. Oh, okay. Now, Hammer staff, would you mind assisting me for a minute and launching the second poll? Because I seem to have relaunched the first poll twice. If that's not possible, we can just go straight to talking. Okay. Can a Senate impeachment trial be held after a federal officer is out of office? A, yes. B, yes, as long as the official is impeached by the House of Representatives before leaving office. C, no. And D, the Constitution does not provide a clear answer. Everyone's going to be deeply dissatisfied with my answer on this one. And all right, I think we should, let's go ahead and I think we're at a critical mass. Let's shut down the poll on this one and share the results. All right, so again, can a Senate impeachment trial be held after a federal officer is out of office? Either yes, this is what I think. I'm with camp answer A, yes, you can. Yes, as long as the official is impeached by the House of Representatives before leaving office. I don't think that's necessary. I think the Constitution does not require that. No, I'll talk about why I think that isn't the proper route here. And then the Constitution does not provide a clear answer. That's also correct. So the answer is, my reading of the Constitution is that yes, absolutely, you can have that trial, but does it specifically say in the Constitution, it doesn't matter if you're still in office? No, it doesn't. All right, let's do, we have 2 more polls, so let's run through them pretty quickly. It's not going to be me because clearly there's a user error involved. So can we go to the next poll, please? Trump was charged with 1 article of impeachment. What was it? A, incitement of violence, B, incitement of insurrection, C, dereliction of duty, and D, election fraud. Why are we unable to fool a Hammer audience here on virtually anything? Now, there were a lot of different potential charges here, and the House of Representatives made the determination we're going to focus all our efforts on one. There was a lot of after the fact hand-wringing. Should we have tried to include X, Y, and Z? They certainly could have. So let's stop this slide, this poll, and share the results. Yes, it was in fact incitement of insurrection, but for those of you who talked about incitement of violence, that is in fact really the federal crime that we typically talk about, and we'll have a brief discussion on that. And dereliction of duty was something that was discussed in the impeachment trial. It wasn't the article of impeachment, but the House managers who act as the prosecutors did discuss it. So let's really quickly do the last poll. And now that the Senate, okay, so I think we already did this one. Let's kind of scrap the polls and move on to the actual discussion. All right, so we are going to start from the 30,000 foot view on impeachment. I was at the Hammer live February 16th, 2020, something like that, talking about impeachment. Let me say, I never thought I would utter the words, the second impeachment trial of President Trump, but here we are. So a lot of what we're going to talk about today, I'm going to say things like, that's not answered under the Constitution. And that's actually not a bad thing, because impeachments are rare and they should be rare. We should not be talking about impeachments every few years. We only want to use this constitutional power, which is like a nuclear power under the Constitution, when the moment arises. And the bottom line is, we really hope the moment doesn't arise in the near future. Only 3 presidents have ever been impeached by the House: Andrew Johnson in 1868, Bill Clinton in 1999, and Donald Trump in 2019 and 2021. None of these presidents were convicted by the Senate. So let's talk briefly about how impeachment works. Could we call up slide number 1, please? So slide number 1 this is Constitution happy hour. So as always, we rely on the Constitution. Article 1, Section 2 tells us that the House has the sole power to impeach. Now let's bring down the slide for a minute so I can see everybody, or at least everybody with their cameras on. What is an impeachment by the House? An impeachment by the House, if we think of this as a criminal case as the corollary, the House basically decides, you know what, there's enough here to indict. There's enough here to say to the Senate, now you go on and hold the trial. So the House impeaching has no legal effect. As we all know, having now lived through 2 impeachments of President Trump, nothing specific happens as a result other than it's a historic moment. People go on record, members of the House of Representatives go on record in terms of how they feel about certain behavior, but nothing happens in the sense that you're not disqualified from holding another office, you're not removed from office, no criminal charges come as a result. The House impeaching, again, is just the House saying, okay, Senate, keep moving. You get to now take this to trial. Now, slide number 2, please. The actual trial happens in the Senate, but it doesn't look like a real trial for a whole host of reasons that I'll talk about in a minute. But what I want us to focus on is the highlighted language here, that the only 2 remedies for conviction in the Senate are disqualification and removal from office. So if we could bring that slide down, please. Now, again, what does a trial look like in the Senate? It doesn't look like a real trial. And it's weird, really kind of strange and confusing because we use the word trial. We treat the senators like members of a jury. We say there's a presiding officer, but only in those few very tenuous ways does this in any way resemble a trial. One, there's not a true judge there. There's a presiding officer. In this case, it was Senator Patrick Leahy, and he's also a juror. In a real trial, you would never have a judge also serve as a juror. In addition, Senator Patrick Leahy, acting as the presiding officer here, he can rule on objections, but then the Senate can overrule him by a simple majority. Again, I'm just pointing out a few different ways in which a typical trial looks totally different from a trial in the Senate. What else? There are no federal rules of evidence that apply. So if people say, well, that's hearsay, or you can't introduce that evidence, the rules of evidence don't apply in an impeachment trial. There's different considerations when it comes to due process. And in this case, the senators who acted as jurors were in fact at least witnesses to the alleged activity, right? They were in the Capitol on January 6th. They were in the Capitol when the insurrection occurred. Now, what else should we be thinking about? Some of the senators were alleged to have actually supported the activities here. You would never have, in a normal criminal case, jurors who were in any way involved in the case. Now, what else do I want us to focus on here? The Constitution tells us that for a conviction in the Senate, we all know this, we've read about this, you need a 2/3 supermajority. That means you need 67 senators to convict. What did we get this time? 57. Now that is actually, you got every Democratic senator and 17 Republican senators, 7 Republican senators. I believe 2 are retiring, 3 are not up for election until 2026. So 5 of the 7 not kind of immediately facing repercussions for their votes. Now, people have said, is this the most bipartisan Senate impeachment trial vote in history? And the answer is yes. 57 actually is the most bipartisan vote that we've ever had. Now, one other thing I want to focus on that we just showed briefly on this slide. There are only 2 possible punishments listed for a conviction in the Senate. One is removal from office, and the other is disqualification from holding a future federal office. Nothing more and nothing less. One of the big questions in this impeachment trial was, could it even be held? And I want to talk about that in just a minute. But again, just 2 punishments can happen as a result of an impeachment. You're removed from office or you're disqualified from holding a future office. Mechanically, how do you get that punishment? Again, think about a criminal case. First, you have to be convicted by the Senate. First, 2/3 of the Senate has to vote to convict. And then you can get your sentence or your punishment. So you can't be disqualified from holding a future office unless you've first been convicted. Now, the conviction vote, again, takes 2/3, 67 votes, but the punishment vote, if you get there, which again, in the history of our country, we have never gotten there. We have never convicted a president. If you get there, the punishment vote is just a simple majority. All right, slide number 3, please. So the next thing, what type of conduct is impeachable conduct? Here again, you're going to hear me say, well, the Constitution doesn't provide us with an enormous amount of guidance. So Article 2, Section 4 talks about treason, bribery, and other high crimes and misdemeanors. So could we take the slide down, please? Now, we know what treason is. We know what bribery is. We don't have a bright line rule for what other high crimes and misdemeanors actually is, but I'm going to offer two thoughts on this. One, you do not have to prove that criminal conduct occurred in order for the Senate to vote to convict. So again, in this case, we used the article of impeachment dealt with incitement of an insurrection. You do not have to satisfy the federal criminal code in the case of impeachment for the reasons that we just talked about. An impeachment trial is separate and apart from anything that would happen in a federal criminal courtroom. So we know that other high crimes and misdemeanors doesn't literally mean that the House managers who are acting as the prosecutors here have to show that a crime occurred. They don't have to show that criminal activity occurred. So if we go to what the founder said, if we go to the Federalist Papers that were written around the time of the ratification of the Constitution, what do we know? That what they were worried about is, quote, public men committing a public offense. So what does that tell us? If a president commits a DUI, presidents don't drive, but if a president commits a DUI, arguably that's not a public offense. What do we mean by public offense? We mean something like public corruption. We mean something like, for instance, leaning on a foreign official and saying, sure, I'll give you this if you give me that, to use a loosely based hypothetical from our first impeachment trial. In this case, if we believe the allegations, inciting an insurrection to what? Thwart members of Congress from doing their constitutional duty of counting the electoral ballots, then that would be considered a public offense. So again, what I want to point out here is that you do not have to show that the person being impeached actually committed a crime under the federal criminal code. And we don't have a bright line rule for what other high crimes and misdemeanors means. Now, slide number 4, please. And we are getting to the end of the slides. So in this case, there was, as we said, there's one article of impeachment, and that's incitement of insurrection. Now, here we have a Cambridge academic content dictionary definition of insurrection. What are we talking about? Actually, different dictionaries use slightly different definitions. I think this is a good one: an organized attempt by a group of people to defeat their government and take control of their country, usually by violence. And then below what we have here is the federal criminal code for insurrection. And I want to emphasize for you, that's here for guidance. Again, in this case, in a Senate impeachment trial, the House picks these so-called House managers. There were 9 in this situation. They act as prosecutors. They do not have to show that the elements of this federal criminal code, 18 USC 2383, they don't have to show that those are violated. Now, let's bring down the slide, please. So we've talked a little bit about the mechanics of an impeachment. The House, as we know, makes the decision about whether or not to impeach. Again, that acts as kind of an indictment. They say to the Senate, okay, now hold a trial. But the trial doesn't look like a criminal trial. We know that the House chooses members, in this case 9, to act as prosecutors. We know that members of the Senate act as the jurors, and that when you're not talking about a sitting president, that the senators pick somebody who's the presiding officer. And we know that, again, the Senate needs to vote by a 2/3 majority, and that there are actually 2 different punishments that can occur as a result of a conviction in the Senate. Now, I want to go back to something that I just said Let's talk about that in a minute. And that's this issue of whether or not you can hold the impeachment trial at all. So in this Senate impeachment trial, the Senate actually voted twice, right? First, they voted on the issue of whether or not you could even hold a trial with respect to a former official, somebody who's no longer in office. And that vote passed by a little bit more than a simple majority. Then they held the vote about whether or not to convict the president. So what I want to talk about first is the first vote. Now, again, the first vote was based only on this threshold question. Can a Senate trial be held for a former official? And we did a poll on this. My answer is yes. My answer is yes for a couple of reasons. And the reasons boil down to the fact that, again, in the Constitution, it says, here are the two things that can happen to you if the Senate votes to convict. You can be removed from office. That's off the table when it comes to a former official, right? In this case, President Trump's term ended. He's no longer in office. He can't be removed. He was removed by virtue of his term expiring. And that person can be disqualified from holding a future office. Now, this is a big part of the reason why I think under the Constitution, you absolutely can hold a trial for a former official. Because if you couldn't, let's think for a minute about what that would mean. It would mean that you can engage in the worst type of behavior, either right before your term ends, and know that you could not be impeached and you could not be disqualified from holding a future office, or it means that you could engage in bad behavior and just say, you know what, I'm going to resign because I want to avoid that potential punishment. Now, that actually happened in the late 1800s. There was a Secretary of War, William Belcamp, and I'm worried for a moment that I mispronounced his name, but we'll keep going. And Paul tells me, no, I pronounced his name well. So William Belcamp engaged in potentially impeachable conduct. He knew he was going to be the Secretary of War. He knew that there was an impeachment looming, and he resigned. The Senate still held the trial. They didn't convict him, but the Senate still held the trial. So the text of the Constitution, the structure of the Constitution, which is designed in a way to hold our officials accountable, and precedent, which shows us that we have, in fact, held an impeachment trial for a former official, all tell me that we can hold those trials. Now, a couple of you have asked about the speech that Senator Mitch McConnell made after he voted to acquit the president. And he said, I'm paraphrasing here, okay, there's no question that the president is morally and practically responsible for what happened on January 6th, but my vote reflects the fact that I don't think you could constitutionally hold this trial. A couple of things to think about. When he was the majority leader, it was then Senate Majority Leader Mitch McConnell who decided not to hold the trial while President Trump was still in office. You could have sped that up. It would have been really, really fast, but you could have sped that up. Two, the Senate had already voted that, in fact, that was constitutional. And Senator Mitch McConnell typically is not in the business of saying that recent Senate votes themselves are unconstitutional. But three, what he said is the president is not off the hook. He could face other types of legal exposure. And I have remarks on that prepared, but I think I'd rather discuss that in the Q&A because otherwise I'm just talking too long uninterrupted. So the short version is the president of the United States does face additional criminal exposure, both potentially based on what happened January 6th, but also based on a whole host of other things that we've been talking about as a Hammer community for the last few months and years now. So before we get to questions, let's focus quickly on the trial itself and what was argued in this trial. So the House managers made the argument that the president, in fact, did incite an insurrection, and they did it, I think, in a couple of ways. One, they said, this is not just about one speech. The president of the United States didn't get up on January 6th and say, I'm going to go to the ellipse and I'm going to make a speech and tell my supporters that they have to fight. And instead, what the House managers show is that this is part of a much broader context of the president of the United States saying the election's going to be stolen. If we don't win, I want to tell you the election's going to be stolen. And then the president after the election saying, I told you the election was stolen. And then third, the president saying, and there's a solution to that steal. You have to go fight. Now, with respect to the speech itself, obviously, there's a lot of different words in a very lengthy speech. There's moments where the president uses words like peacefully. But what the House managers said is, look, you don't get to tell somebody, go rob a bank, but try not to cause any harm. The broader message here is a clear one. The other thing that the House managers did, which again, the first thing they did, put that speech in a broader context. The second thing that the House managers did is I think they really showed the senators you were in danger. And they spent a good deal of time showing security camera footage, sorry. I was trying to say video footage. And they showed that this was a situation where not just Democrats, but Democrats and Republicans were in danger. This is why there was lengthy discussions about what about Vice President Pence, because House managers don't want to make it look like we just care about Democrats. This is also why we saw the video of Mitt Romney literally at one point running for safety. Again, putting this in a bipartisan context. Now, what standard of proof do the House managers need to satisfy to get a conviction? Here again, the Constitution does not give us an answer. The Constitution does not require that it be proof beyond a reasonable doubt. We're not in a criminal courthouse. The Constitution doesn't require that it be clear and convincing evidence. The answer is that we're just not sure. And the Senate can really vote its conscience. As Senator Mitch McConnell said, vote your conscience. Now, what was President Trump's defense here? Again, very briefly, his defense fell into a couple of different buckets. First, they continued to argue, even after the vote, that the Senate could proceed with the trial. They said, this trial is unconstitutional. And we heard that again throughout, from the first of 5 days to the last of 5 days. The next thing that President Trump's defense team said is the president didn't, in fact, incite this insurrection. And they really tried, when you have the president's speech on the one hand and then the insurrection on the other, they really tried to cut that connection and say you cannot draw a direct line between those two things. The kind of next two things that the court said, that there are First Amendment defenses here. That in fact, the president of the United States was engaging in political speech and you can't punish him for that speech. And then there were arguments largely based on due process. And again, we're not in a criminal courtroom. I think some of those arguments were not particularly well founded. So what happens? As we said, the Senate votes 57-43 to convict. All the Democrats plus 7 Republicans. Now, where does this leave us? President Trump faces potential criminal and civil exposure. And we've actually already seen the first of those cases, I believe, was filed Monday afternoon by the NAACP in support of a number of members of Congress. They sued under something that we call the Ku Klux Klan Act of 1870 and 1871. And I'm happy to talk about that case. But with that, It is 5:39, and I believe I lied to everyone when I said I can do this in 15 minutes. So this is Hammer form. This is my official. Let's turn it over to Q&A.
So now that we're going into Q&A, I just want to say that you might want to change your Zoom settings now. I recommend going to gallery view so that you can see everybody else in the audience. We want this to be as interactive as possible. So we have 3 ways that you can ask questions. You can either raise your hand to ask a question out loud. You can raise your hand digitally using the blue button, which is a Zoom button that you can find if you go to the participants label at the bottom center of your computer or your phone screen, and then you click on the button labeled raise hand. Or you can physically raise your human hand. When we call on you, we're going to prompt you to unmute your audio, and you can go ahead and ask your question live. Or alternatively, you can type your questions into the chat box below, and I'll read them out loud to Jessica Levinson. So if you've already typed your question into the chat, but you'd like to ask it directly out loud, please go ahead and raise your hand now. And we're going to try to get to everybody's questions, but we again apologize if we can't get to all of them. And just a quick reminder, this is being recorded. So if you don't want to be recorded, please turn off your video, and you can still type your questions into the chat box at the bottom of the screen. And now I am going to pick Janet Leader. Janet, do you have a question for us? Can you unmute yourself?
Wow. Hi. Thank you again, Jessica, for your brilliant summation. But my question was, I heard that different states are actually censoring the senators that voted the Republican senators that voted guilty, and the North Carolina Republican Party said they were censoring him because he first voted that I think this was Senator Burr, that he voted that the trial should not take place. It wasn't constitutional. But then because the Senate voted that it was constitutional, he felt that he then could go ahead and vote that Trump was guilty, but he's being censored by his state, I guess, Republican Party for that. Can you address his legal right to vote yes or no, or how that goes?
Sure. Well, under the Constitution, the senators have the right to, well, I should put it this way. Under the Constitution, the senators have the duty, obviously, to vote. I'm pausing here because the answer is there is no repercussion for your votes, right? This is a political form. And the first, second, and third things to know about an impeachment trial is that it's not a criminal courtroom. It's held in a political form. The decision is made by political actors, and the repercussions are political ones. The repercussions are accountability. The repercussions are you might be voted out of office. The repercussions are you might face a primary. But in, clumsy answer to your question, it's not a dereliction of duty to vote to convict. It's not a dereliction of duty to vote to acquit. You have the power. As a senator, you have the authority. And it's not like a juror who doesn't adhere to jury instructions, for instance, in a criminal case. So you don't have to account for your votes as a senator. The members of the electorate will likely require that you do, but you have discretion to vote as you want. Does that answer your question?
Yes, it does. I guess the question is, do they have the right in his state, which is North Carolina, to censure him? But I guess they can censure him on anything they want to as well.
Yes. So do they have the right to censure? Yes. A censure is basically a statement that happens on the official record of how deeply disappointed we are in our elected officials. So some people said, why don't we just censure the president? Again, a censure is just symbolic. It doesn't carry any legal repercussions. It doesn't mean you can't run for office again. It's just your colleagues saying, we're so angry with you that we don't want to just say it on the Sunday morning talk shows. We want to have it in the official record.
I am going to call next on Sydney Lamb. Sydney, can you unmute yourself? What's your question?
I have two quick questions. One, did Leahy, as presiding officer, at any time have the ability or the right to reprimand either the House manager or Trump's defense team for making misstatements, falsehoods, or just outright lies? And question number two, are there any grounds for disqualification of the senator from being a juror for not doing his job, specifically Hawley sitting up in the balcony and reading some documents rather than pay attention to the arguments?
The second question is no. I mean, you know, the senators could decide to have a meditation in the back. They could decide to, you know, read comics. They could decide to walk out of the room. I think at a number of points, there were only about 65 to 70 senators in the room. There's no constitutional requirement that they sit there. There's no constitutional requirement that they treat an impeachment trial with any level of respect. There's no constitutional requirement that they pay attention at all. So that's your second question. As to your first question, could Senator Leahy, as the presiding officer, have said, okay, we've already ruled on the issue of whether or not there's election fraud, or that's actually not what the record says? The presiding officer has discretion to essentially reprimand, but I think that what we've seen is that the presiding officers, and think back to Chief Justice John Roberts, what was it now, 13 months ago, really don't want to play a large role. What we heard both Chief Justice John Roberts and Senator Leahy say is some version of, let's try and respect the decorum of this particular moment. But there was no specific comment of, look, we've already litigated the post-election case. Judges have already decided that. Could he have decided to step out and say something like this? Yes, because the Constitution doesn't tell him you can't do that. Then we're under Senate rules and procedures when it comes to an impeachment. And I believe under the Senate rules of impeachment, he could have taken a more active role, but he had no desire to do so. Does that answer your question?
Yes, but it's also disheartening to hear that what happened was basically not a trial. It was more like political theater, if not a farce, by not following certain principles that you would have in a criminal trial, such as a juror being able to be disqualified. So here you could do whatever you want. You could say whatever you want with no condemnation or comment from anyone other than the opposing parties. But you did answer my questions. Thank you.
It was a depressing answer, but an answer. Claudia.
Just to add on to Sydney's, maybe, Jessica, do you want to reiterate about the difference between a criminal trial and an impeachment, which is really a political thing? It's not a criminal trial. Could you maybe explain that a little further?
Yes. So in every way, I mean, I think the greatest similarity is that we use the word trial. And that is kind of the beginning and end of the similarities here. So the other similarities are, we call people jurors. Again, in a typical criminal case, you would go through a process called voir dire, and you would ask the jurors to make sure that they're neutral, that they could go into this particular process with an open mind, that they weren't overly biased. In this case, the senators do take an oath, but we saw some of the senators, in fact, talking to President Trump's legal defense team, and there will be no repercussions for that. You could never, in a normal circumstance, have members of the jury conferring with either the prosecution or the defense during the trial. What else is different here? Again, there's not a judge in the typical sense. Senator Patrick Leahy could make determinations based on objections, but he could be overruled by a majority of his colleagues. There's no judge in a state or federal case who would ever understand or think, because they can't, that they would be overruled. Claudia.
So in a sense, it really is political theater.
Well, it's all happening in a political forum. Yeah, so everybody involved is a political actor. The House managers are not professional prosecutors. I mean, these House managers almost all had a background in law enforcement or as being a prosecutor, but the House managers are not prosecutors, they're political actors. The jurors, political actors, the presiding officer. This really is all happening in a political forum. And that's why for impeachment, I'm afraid that one of the most important things really is just how many Republicans are in the Senate at that time and how many Democrats are in the Senate at that time.
So we're going to go to Dave in a second, but I'm going to use my moderator's privilege to throw in another quick question. You've said many times it's not in the Constitution that this happens in an impeachment. It's not in the Constitution that that happens in impeachment. We've all seen the constitutional text now. We realize that it says very little about how an impeachment should happen. If every single human being in Congress today said, we want to codify what an impeachment trial really should have and actually write it up so that there's very clear guidelines, is that even possible? And how would that work? And where would the instructions live? Are they in the criminal code or where do they live?
So there are Senate rules of procedure when it comes to the impeachment. And that's, for instance, why we know what time an impeachment trial starts. It starts at 12:30. We know, the rules basically give us kind of a roadmap for how the trial is supposed to occur. Let me emphasize how little like a trial this is, in the sense that there were no witnesses in this case. Typically, we're used to witnesses. There was some question in the first impeachment trial as to whether or not there could be a quick kind of hand vote. Just should we even go on and have anything more than just a vote on this particular case? Would that satisfy the trial requirement? So Claudia, to your question, it wouldn't live in the criminal code because that's just completely separate and apart from impeachment proceedings. And it wouldn't in any way supersede the Constitution. It would be the Senate, as a matter of their rules and procedures, dictating what's going to happen in an impeachment case.
Got it. Thank you. And now let's go to Dave. Can you unmute yourself and tell us your question?
Yeah, I wanted you to talk about past after the Civil War, but I think it addresses the issue of banning people from office who are engaged in insurrection or war against the United States. And would that be applicable in this case?
Yeah. Can we still actually we have a slide on that. Is it possible to call that slide up? And if it's not, that's fine.
Which slide number is that?
7 or 8. It's the last slide. All right, so I'll try and shorthand this. No person shall be a senator or representative in Congress or elector of president or vice president or hold any office, civil or military, under the United States or under any state. Now, it doesn't specifically call out the president in this case. It specifically calls out members of Congress, and it specifically calls out the Senate and electors, but it doesn't specifically call out the president. So question as to whether or not this would apply to the president. And then it says that you shall not have engaged in an insurrection or rebellion against the same or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. Now, could we bring down the slide for a minute? Okay, so typically when we talk about the 14th Amendment, we think about things like equal protection and due process. This is different. This basically says if you're a senator or a member of Congress, or maybe even the president, don't engage in insurrection or rebellion, and don't give aid or comfort to people who do. Again, it was passed in the wake of the Civil War, and Congress used it most often in the 1860s to prevent former members of the Confederacy from being seated. Now, could it be used now? The answer, I think, really is no, because the current members of the Congress have been seated. Now, there's a potential argument that you could use it to prevent a member of Congress who maybe supported the insurrection from being seated if they're reelected in 2022. I think that's an incredibly hard constitutional road to tread. I do not think that's likely. And then even more difficult would be to use Section 3 of the 14th Amendment to say to the president, if he ran and was elected, actually, we're not going to seat you. We're not going to allow you to be inaugurated because of your support of January 6th. That really would be so-called constitutional hardball. It would be unprecedented. And I don't see that happening, but it is certainly something that, people have talked about. It is one of the least discussed sections of the Constitution. But again, I don't see it working for members of Congress, and even less likely for President Trump if he were to be reelected.
Okay, we have two questions that are related to each other, so I'm going to put them into one question. Deborah De La Torre asks, is it required that the senator's vote to convict be public rather than through a secret vote, or is this something that gets negotiated before the Senate trial? And the follow-up, Lucy Mipos asks that, do you think that if the vote did not show the senators' names, for example, i.e. that it was anonymous, that the outcome would have been different?
So under the current rules, it's a public vote. You could change that by a majority vote of the Senate. So you could decide to have a secret ballot. Do I think that would have changed the outcome? It's a little bit more for a political scientist than a law professor, but my suspicion is that there were a number of Senate Republicans who were worried about somebody running against them in the primary and or losing in the general election, and that it's not a complete coincidence that five of the seven who voted to convict are either retiring or not up again in 2026, until 2026, excuse me. I think Mitt Romney is the one who's up the soonest, and he's been very clear about his position from the beginning.
Got it. Thank you. And now I'd like to call on Janice Motner. Janice, can you unmute yourself?
Thank you. I'm interested in going back to McConnell's somewhat bizarre speech at the end, in which he touted the guilt of Trump, but had refused to allow the trial to take place, and then said that Trump couldn't be convicted because he was then out of office. And I'm just curious, number one, why isn't this bizarre hypocrisy not being discussed and dealt with more? And is that truly a constitutional reason for acquittal?
Janice, you asked that question like we don't know each other. Hi, nice to see you.
Hi,
Okay.
Jessica. I had the honor of interviewing Jessica myself, and has been a wonderful person in my life to give me great insights. So it's great to be here with you, Jessica.
Oh, well, it has gone both ways. So, in terms of Senator Mitch McConnell, I think he's absolutely within his constitutional discretion to have said, I'm not calling let's talk about all the decisions he made along the way. First, he decided that he was not going to try and call the Senate back. Come back early and let's have the trial before the term ends. I don't think he's in any way constitutionally mandated. And in fact, I think he played the long game and made a decision that if he didn't, there was going to be at least a reason for him where he could say, look, I'm just voting to acquit because I don't think that we should have this trial. I'm not weighing in on President Trump's particular behavior here. And then I think he was absolutely within his discretion to make that speech on the Senate floor. Now, it's not illegal for him to say, I'm delaying the trial, and then I'm voting to acquit because the trial came too late. Let's remember, this is not meant to sound like a cheap shot, but let's remember this is Senator Mitch McConnell, who when in February 2016, when Justice Scalia passed away, said we're not going to have hearings for Merrick Garland. We don't have hearings in a election year. And then September 20th, 23rd, my memory's failing me, 2020, we are in an election. We are voting. It's not an election year. We are voting. Senator Mitch McConnell says, absolutely. We're holding those hearings, and we now have Justice Amy Coney Barrett. Now, he said the difference is that there was a divided government in 2016 and there wasn't in 2020. I think constitutionally that makes absolutely no sense. But again, I don't think that he violated a constitutional duty. I think that's really more a question for his constituents as to whether or not they're comfortable with that. The answer for Mitch McConnell, if we have a problem with his behavior, is political pressure, but you can't haul him into court. And in fact, I would feel uncomfortable saying that that is an impeachable offense, and that might be a unpopular view. But I don't think that we should treat that kind of long-term strategy for his and or his party's best interest as impeachable conduct.
So we have a couple of other people asking about impeachable conduct. I'm going to read them right here. Dana Silva says, thinking back to the Clinton impeachment, it seems that the scope of other high crimes and misdemeanors has been interpreted fairly broadly in the past. Historically, have any charges been brought that were held to be outside the scope of impeachable conduct? I think she means in an impeachment hearings. And then we have a related question from Patricia saying, what was the thinking behind not including dereliction of duties from the charges against President Trump?
Yes. So in answer to the first question, and then I feel like I'm going to have to ask you to, the dereliction of duty. So in answer to the first question, no, I do not believe that a court has ever said that's not impeachable conduct. And remember, the Constitution says the House has the sole power to impeach, and the Senate has the sole power to try those impeachments. Courts really don't have a role here. And in fact, I think virtually any federal judge would say, oh, not it. I'm not weighing in on this. That's a political question. The Constitution very clearly gives that power to the House or to the Senate, and I'm out. So no, I'm not aware that we've ever said, oh, that goes too far. You can imagine a quote unquote private crime where the House would decide to impeach. And I think that would then fall within the conduct that we would include in impeachable offenses. Dereliction of duty. Why wasn't that included? I think that the House made a decision that it was much more forceful to harness all of their energy and focus on this one article of impeachment. But they did have a discussion in the trial. The House managers talked a lot about dereliction of duty. And I'm not actually sure that that was the right call, in the sense that it gave the defense something to argue in response. It gave the defense a moment to say, if you're worried about dereliction of duty, why didn't you include it in the articles of impeachment? I think what the House managers, frankly, were trying to do, it was a little bit of having it both ways, a little bit of one article of impeachment, but then I'm also going to talk to you about other things. But I also think that it was valid in the sense that part of the incitement, part of the case for incitement of insurrection was to show the president's state of mind and to show what he knew going into the speech, what he knew on January 6th, and what his reactions were. So that's part of the reason why there was this lengthy discussion about whether or not we would have testimony with respect to a phone call between House Republican leader Kevin McCarthy and the president, where allegedly Kevin McCarthy says, Mr. President, we're in a terrible situation here. Call off your supporters. And President Trump says, well, Kevin, I guess these people just care more about the election than you do. Again, allegedly, we don't know for sure, or I don't know for sure that this is exactly how the conversation took place. Now, why does that matter at all? Because it goes to the president's state of mind. And insurrection asks us two questions. And I felt like I was going on too long, so I didn't talk about this in the original presentation, but insurrection asks us, was there speech that's directed towards inciting unlawful behavior, in this case, an insurrection? And was the speech likely to incite an insurrection? And so, for instance, it's not incitement if you say, gosh, we have such a terrible problem in Washington, D.C. We should really just throw those people out. Nobody really understands that to mean go to the Capitol and start throwing members of Congress out of their offices. What's different is if on a certain day you hold a big rally and you say, Congress is going to certify fraudulent election results today. We really have to go do something about it. And this is specifically what we together have to go do. We have to march. We have to take this route to walk. Then we have to, quote unquote, fight like hell. And that's much more specific, much more immediate. Again, it's the different, think about how much context matters in these cases. So think about the following comment. I am doing the laundry and I say, I asked my husband to do this, I'm going to kill my husband. Compared to, I am loading up a duffel bag or a backpack and I'm putting a knife, a gun, and I say, I'm going to kill my husband. Context really matters when it comes to speech. Okay, so that was an incredibly long answer to, I'm not sure if they made the right decision to not include dereliction of duty, but they were trying to bring it in to show that the president was not, in fact, performing the responsibilities and duties of his office. And part of that is to show where his head was and to prove that there was, in fact, incitement.
I have a question I'm going to read to you, and also Ruth Strauss has her hand up, but Ruth, I've messaged you in the chat. We're not sure if you're ready to ask a question, so I'm going to read a question, but if you could make yourself visible if you'd like to ask your question, that'd be great. So now I'm going to read two related questions from Catherine Long and Polly Calhoun. Polly Calhoun asks, if the real fear that the framers of our Constitution had was of tyrannical rulers, why didn't they create more options for the people to remove a president from office? And Catherine Long asks, if a riot in which people died, our police force was attacked, and the Capitol building was vandalized, if that's not enough to get the 2/3 majority required for impeachment, what are the odds that anything will ever meet the standard when votes are so partisan?
I don't know that you could have reached the standard with the Senate. I mean, it is, again, only speaking for myself, it is hard for me to contemplate behavior that would have reached the standard at this point. The senators were in the Capitol. I was able to interview a member of Congress about this, and she said, I was on my hands and knees crawling across the House floor. I did not leave the House chamber because my colleague was too infirm. We were trapped. the only reason I had to pull off my gas mask is because I couldn't hear what the Capitol Police officers were saying. She said, I absolutely thought I was going to die that day. This is not a particularly unique story. These are elected representatives. This didn't happen in somebody's private company. This happened in the people's house. And there were literally members of Congress and senators running for their lives. And I don't want to sound hyperbolic or sound like I'm trying to over dramatize here, but I mean, when you hear the story over and over again of I had a gas mask on, I was on my hands and knees. We were barricaded behind chairs. I was hoping, you know, we started a group text about bulletproof vests. It's personally hard for me to think about the type of behavior that would be, that would lead to a conviction after that.
So then going back to Polly's question,
Yeah.
if our founding fathers are so clever, why didn't they set this up better so that people could be removed?
So this is my feeling. The founding fathers absolutely thought, and members of the Hammer audience would have maybe have heard me say this, they absolutely thought we were going to lie to each other kind of a little bit, right? That's why we have these three pillars. That's why we have a legislative branch, an executive branch, and a judicial branch, because we were very worried about anybody having too much power. And we basically assumed that you can't trust anyone too much. So Congress is going to have a watchdog function over the executive. The judiciary is going to have a watchdog function over Congress and the executive. In some ways, we can have a different discussion about judicial review. And there's the idea that we have to share power because we can't trust anybody too much. The president can only serve 4 years before there's another election. The president can't serve more than 8 years. All of these are ways that we basically say to our officials, we're worried, we don't trust you. We want to be able to remove you. What the founders did not foresee is, I think, again, just speaking for myself, what we saw over the last 4 years, which is a total breakdown in Congress's watchdog function. I don't think that the founders anticipated, they thought that there would be different ideologies, different factions, but I don't think they saw the political parties the way they currently function. I think they saw political parties more like in the Nixon era, where it became clear President Nixon had to resign. He didn't, in fact, face impeachment because there was bipartisan support for lack of support for him. It's really troubling when it comes to an impeachment trial. And the most important question is how many Democrats are in the Senate, not what are the charges, what happened. The most important question is how many Democrats are in the Senate or how many Republicans are in the Senate. So why didn't the founders think about more ways to remove the president? I would actually say they did, right? We have fairly frequent elections. We have term limits. We have a power sharing structure. We have an impeachment provision. We have later, again, we have the 25th Amendment. So it's not like we don't have the constitutional mechanisms. We just didn't use them.
Okay. Thanks for clearing that up. Now we are going to go to a question from Ruth Strauss, whose video is not working, but we're going to hear from her. Ruth?
Hi, thank you so much. So a couple of these things you could just answer yes or no, but one thing is the 14th Amendment does say an officer of the US, so I assume a president is an officer. And the other thing is there was a vote to proceed. So it wasn't as if, you know, people all agreed that, well, he's out of office and so he shouldn't be tried. So that was one quick thing. The other was, I believe I understand that you can't prevent from office if you haven't convicted the person. And finally, just a quickie, you said correctly that, the judicial branch is not in it, but why then is the Chief Justice presiding? And that's it. Thank you.
Sure, absolutely. Okay, so why does the Chief Justice preside? The Chief Justice presides only in the case of a sitting president. And I think the idea is that it's just too awkward to have a senator preside over that particular type of trial. Do you have to be convicted in order to face a punishment? I think the answer is yes. It's just like a criminal trial in the sense that first the jury has to say, we vote to convict, and then we decide what's the punishment. Is it 1 year in prison, 2 years in prison? Is it probation? So you have to have the conviction before you have the punishment. Was there a vote to proceed? Absolutely. The Senate voted, yes, it is permissible. We're going ahead with this trial. And under Section 3 of the 14th Amendment, it says officer. Doesn't that include the president? My answer would be yes. I think the better reading is that it does include the president, but the people who wrote Section 3 of the 14th Amendment did call out certain people, and they didn't call out the president. So just as a matter of constitutional interpretation, why didn't you use the word president? You said electors of the president and the vice president, but you didn't say president. Now, this gets back to, we had I think maybe 10 months ago, we did a HAM reform where we touched very briefly on the idea that the emoluments clause does not specifically call out the president of the United States. And it's something very similar where they talk about other offices, but they don't say and the president. So the answer is, I think that you could say an officer does include the president, but the response is, hey, people who wrote Section 3, if you wanted to include the president, you knew how to write senator, you knew how to write member of Congress. Why didn't you just include that other word?
Okay, thank you.
Sure.
Now we have 3 questions that have to do with trial procedure. One of them, Mike asks, why couldn't the prosecution hire their own lawyers since the defense had their own lawyers? It seemed like an unlevel playing field. I will point out that a lot of the impeachment managers were former prosecutors, but please address that. And then the second question about trial procedure is from Janice Motner. Many people said that calling witnesses would not have helped the prosecution. But what is your personal view, Jessica Levinson, and which witnesses would you have wanted to hear from? And Polly Calhoun asks, how and why were senators/jurors allowed to meet with counsel during the trial? Though it's not in the Constitution, isn't that a total conflict of interest?
Yes, but it's not in the Constitution that they can't, and there will be no repercussions for that. I mean, doesn't it totally subvert the idea that they would be in any way neutral? Of course, absolutely. Should they have called witnesses? I actually went up and back on this one. I think that in some ways it would have been really powerful to call the police officers in and say, tell me about what happened on that day. So when you were backing up and running for your life and trying to protect members of the Senate and trying to protect members of the House, tell me about how you were feeling. Tell me about what they were screaming at you. Tell me about the racial epithets that they were screaming at you. Call members of Congress. So when you went back to your office that day and you were holding a baseball bat as your only protection, what were your thoughts on what had just happened? Again, the rules of evidence don't apply. So you can have people come in essentially to give an impact statement. Now, I think that members of the House impeachment managers would say, well, we made our case with the video. And I think the video was extraordinarily powerful. I also think that there was political pressure to essentially allow, President Biden has not very much time to get an enormous amount done. And I think there was political pressure to say there aren't 67 votes. Let's keep this train moving because we need COVID relief. And remember that part of the discussion about whether to call witnesses was Republicans saying, I'm going to hold up COVID relief. That sounds like a political statement, but it's more of a statement of the reality of, what was happening in the time of the impeachment. And then, so sorry, I have, and then the House manager, should they have called in professional lawyers? I actually think, and this goes, Claudia, to the point of the most important thing about an impeachment is that it happens in a political forum. I thought the House managers way outgunned the defense. I thought the defense was completely out of their league. You did not have constitutional law professors. Notice that no one who was on the Trump defense team in the first impeachment came back for the second impeachment. And in fact, this was a reconstituted trial team that I think that this was the new trial team that was made 6 days before the impeachment because the previous trial team had all resigned en masse. Now, could House managers have asked for outside counsel? Yeah, I think that they could have. But again, Ted Lieu, I believe, was a prosecutor, Eric Swalwell. There were, I think, almost all of them had acted as either county, state, or federal prosecutors. So this was as in my mind, a qualified group that didn't really need outside counsel. And I also think it was powerful for them to be able to say, think about Jamie Raskin, a constitutional law professor. Much more powerful to hear that story from him as opposed to another lawyer telling his story.
And then, of course, they had Mitch Mcconnell.
Yeah, right. They had, somebody joked, Senator Mitch
An hour
MccConnell,
too late, but
right, that if that speech had come in 5 days earlier, it might have been a different story.
well, so next question looking forward comes from Evelyn, but I know that you wanted to address this towards the end of tonight's program. Can there be a criminal case against Trump now that he incited people to violence? And I'm going to add to that, what do we have in store in terms of future cases against Donald Trump, the private citizen?
Yeah. So the answer is yes. Again, what happens in an impeachment trial is separate and apart from anything that could happen in a criminal court. So the president could be tried in a criminal courtroom based on January 6th. I don't think that's very likely. And I know that might disappoint some people or it might make some people happy, but we had a slide that showed under the federal law what you need to prove for incitement of an insurrection, for incitement of violence. And remember then, in a criminal courtroom, there's going to be a vigorous First Amendment defense. Now, the defense would be, I was engaging in political speech. You can't punish me for political speech. That's the top of the type of speech that we care about. And that's the absolute, most sacred and protected speech. I think that it would be a winnable case in federal court. But my gut tells me it's not going to be brought. What I think is a lot more likely are charges based on different behavior. So let's take first, I won't go to my notes, I'll do the short version of this. First, let's talk about what could happen in federal court. Think back to the Mueller report. There was a discussion of obstruction of justice in the Mueller report. Think back to Michael Cohen's, the president's personal attorney, and his testimony, talking about potential campaign finance violations. Think about potential wire fraud issues dealing with the Trump organization and financial crimes. Now, let's leave federal court for a minute. Let's go into the state court. In New York, there is an investigation both by the New York Attorney General when it comes to civil issues and the New York District Attorney when it comes to criminal issues. What is New York looking at? Basically financial crimes related to the Trump organization, potentially crimes related to inflating or deflating the value of businesses in order to try and get loans. And let's not forget, Georgia is looking into potential election fraud. So this is not, an impeachment is not a legal proceeding, but this is certainly not the end of the president's legal troubles.
Isn't the inauguration fund
Yes, thank you.
another big one?
Yes, yes, there's some investigation into the president's use of the inauguration fund and donors. And this all kind of broadly falls under this rubric of public corruption. And I think, frankly, kind of to President Biden's chagrin, because I think he wants to just move forward, we're certainly going to be talking about these cases for a while.
Is tax fraud on that list now that we know? I mean, after over 10 years, did he pay $800 total tax?
So that doesn't, I know this is going to sound a little strange, but that doesn't necessarily indicate fraud. But I absolutely think there are investigations into at least the Trump Organization financials. And that's part of what the New York Attorney General, Letitia James, is looking into. And the New York District Attorney, Cyrus Vance Jr. There's been an 18-month criminal grand jury investigation in that case. And that I absolutely think is one of the things they're looking at.
Well, it looks like we have a lot to keep talking about in the coming years. And we are very grateful to have Jessica Levinson here to guide us through all of these complex issues. I think it's 6:30, so I think it's time to wrap it up for the night and go have our dinners. But I want to just thank Jessica Levinson. Thank you so much for speaking with us today. And thank you to our wonderful Hammer audience for coming out tonight. It's such a pleasure to see all your faces again. I can't wait till we can gather in person. I think that will happen sooner than expected. And in the meantime, I hope you'll come back to our next program. We're planning one for next Thursday night about vaccinations and teachers and reopening the school system. And we have another one in the works about vaccine equality and equity issues. And we'll also be talking pretty soon about family separation and detentions in centers at the border. So stay tuned and please come back to our future programs. And thank you all. Feel free to unmute yourselves and say hello.